If you're new to my channel, my name is Karen Cole from Legal Minded Friends.
And today we're going to discuss the Chief Public Defender who represented Bryan Kohberger, the man charged with the 4 counts of first-degree murder of 4 Moscow, Idaho University students for the extradition hearing in Pennsylvania. Was it a wise move? In comparison, I'm going to let you know the rules of conduct in the UK for barristers and solicitors speaking out. If you have not heard what he said or just need a reminder, let's play a portion of a couple of clips. And straight after that, I will play another clip of an opinion given by a lawyer. He's actually called the lawyer you know, Peter Tragos of Tragos Law in Florida. Then we'll look at the rules of conduct in the UK, as I think you'll find the comparison very different, yet similar in some ways.
And I spoke to him for about an hour. I let him know about the statement, that I wanted to get a statement out there because with all of the news media, I knew there was going to obviously be issues as far as him receiving potentially a fair trial, people jumping to conclusions. You know, automatically you worry about the presumption of innocence and the integrity of the criminal justice system. So I said, Bryan, is it okay if we get a statement out? And that's when he brought up the eager to be exonerated language. And obviously that was included in the statement.
So that was him. That was him who wanted to put that in.
The eager to be exonerated was the language he used. We put it in the statement. But obviously when I talked to him about the eager to be exonerated, to me, when we talked about it, it was more or less he was asserting innocence, but that's the language he used.
Jason, you were his attorney maybe for 4 or 5 days, something like that. How do you keep in contact with his public defender out there in Idaho? Or are you just kind of done and observing this?
I'm merely done and observing and really viewing everything objectively because I was really working in the dark and blind when I represented Bryan. The affidavit of probable cause wasn't even available to me. So I couldn't even discuss the affidavit, even if I wanted to, with him, because really I didn't want to, because I didn't want to reveal anything about the case that would be specific to the facts and circumstances with him.
It's really the only statement that we had that came from him directly. He's eager to be exonerated. He was helping craft the public statement that was made by the attorney.
Yeah, what was interesting is the attorney said, he went to Bryan and said, I think we should do a public statement. What do you think about that? So it was the attorney's idea to do the public statement. But then the language basically more or less saying I'm innocent is what he said, Bryan said. He was eager to be exonerated was Bryan's words. To me, that just shows I would expect a not guilty plea, right? And I would expect some legitimate theory of defense, not just poking holes. Pennsylvania public defender speaking out to me was a little bit less appropriate. He may not say that again.
It's in the gray area.
Yeah, exactly. And I mean, from my perspective, I would never do that if I was still representing somebody, or I shouldn't say, even if I wasn't representing them anymore, the attorney-client privilege still lives. And that stuff is still confidential. A lot of it, I should say. There are some that is already public or has already been told to other people. So that may make it less confidential or protected. But I think he probably said a little too much, and he may not be under the Idaho rule of law, but he could be considered part of the defense team. If he's still working with the Idaho defense team, the Idaho defense attorneys, he could be considered one of their agents. So I do think there are ways to get him under that gag order that maybe have not been thought about yet. And I probably wouldn't have done it if I was him.
Okay, so now you have a bit of the background of what the former chief attorney for Bryan Kohberger said and the opinion of from the lawyer you know. Now let me get into an article that was in the councilmagazine.co.uk. I'll read a portion of it, and if you're interested, as always, you can see the links below, by the author Patrick O'Connor, KC. And if you're not familiar, KC stands for King's Counsel, and this is awarded to advocates who have demonstrated exceptional ability. Some of you may be familiar with this accreditation, previously recognized as QC, Queen's Counsel, found after a name, though when the monarchy changed, After our beloved Queen passed away, her son Charles became king, hence the change from QC to KC. And if you're a barrister or a solicitor and are interested in applying for this status, I will play a clip before ending this video that I'm sure you'll find very interesting. So let's get back to the article. So the big question for today, should counsel be allowed to express a personal opinion about their cases in public when they cannot do so in court? And the reply is, the role of an advocate is not to act as a mouthpiece or to identify with the client's cause. Managing the media as a litigation tactic should not be perceived as part of the service offered, nor should trial by media be encouraged. Opinions expressed on social media create even greater dangers. An impression of self-promotion may violate core duty 2 in the rules of conduct. And I can't help wonder if this was the case in the Bryan Kohberger case. Was the solicitor, the attorney that represented him in the extradition hearing, promoting himself, when at the time he had not even seen the probable cause affidavit? So why did he push to get a statement out? Was it to get a fair trial, or was it a litigation tactic? I encourage you to watch the clip and decide for yourself. Okay, back to the UK article. Any expressed personal opinion must be true and honestly held by the barrister or solicitor. Particular problems arise if this is only partly supportive of the client's case. Later courtroom submissions may be compromised. The opinion may be refuted by later developments. I think this is the point Peter, the lawyer was saying when he said the former attorney had said too much and maybe should be under the Idaho gag order. In my view, this would ensure later submissions in court are not compromised. I sure think to have a fair trial, he should not have spoken out. And it is very astute of the lawyer to make this point. So check out the clip he is in from Tyler Feller's YouTube channel. So this article is really good, and it gives a bit of history. For example, before April 2013, barristers were not allowed publicly to express their personal opinions about any of their anticipated, current, or past cases. And this prohibition was founded upon the rule against advertising. The bar has since changed their rule. Barristers are now allowed to publicly express a personal opinion about their cases, exercising their freedom of expression, subject to core duties and certain guidance. So the article is very good for looking at what was in the past and what is current. So please check that out. I've left the details below. So there you have it, some of the differences. What do you think? Was the former attorney for Kohberger speaking out because he thought there would be an issue with the public jumping to conclusions, or was he just trying to influence the public opinion with a litigation tactic, or was he just trying to promote himself? What do you think? Was he simply reminding people of the presumption of innocence? A lot of food for thought there. So leave a comment and tell me your thoughts. And for those of you who are solicitors or barristers out there interested in applying for King's Counsel status, I will leave you with this clip to end on.
I didn't really have a motivation for taking silk, in the sense that I was at a judicial conference. One of the judges said to me, have you ever thought about taking silk? And I looked at her and I looked a bit blank and smiled and said, but I'm not a barrister. And she said, oh, you don't need to be a barrister. Self-confidence and a belief that I was too different nearly put me off applying. I spent a lot of time preparing my application form, and as I was due to put it in, I was on the phone to my colleague and I said, I'm not posh enough, I'm not barrister enough, and I'm not the same enough. This is ridiculous. And she said, if you self-filter, how can the QCA ever appoint solicitor advocates? Because they won't have any to choose from. So it was the belief that I was too different was my biggest inhibit and worry. In terms of ensuring success in the application, be yourself. There were lots of times where I kept thinking about the fact that I needed to be male, middle-aged, in a tie, barrister, wig, etc. And I realised that the only way to succeed was to be me. Seek counsel and support from people around you, share your application form, be challenged on it, and then don't defend your own position. Take the advice, listen to it, and adapt, but ultimately just be you.
Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact Legal Minded Friends.